I'll be pleased to, for public edification, to speak on the matter. First of all, I believe the public is aware of a letter sometime late last year, that was sent to Ms. Joseph from the lawyer on behalf of the Prime Minister, Keith Mitchell, claiming libel with respect to remarks made by Ms. Joseph in, I believe, an NDC interview. I was consulted by Ms. Joseph, and we did a press conference with respect to the demand in the letter that was sent. And Ms. Joseph's position, as I communicated then to the press, was that she intended to defend that accusation, that allegation, as strenuously as she could. And also that she was not prepared to pay either the $350,000 that was demanded on behalf of our Prime Minister, the dear Dr. Keith Mitchell, nor to pay 1 cent.
I recall.
And that was very clear. So everyone, the entire nation knew what the position of Ms. Joseph was regarding that allegation of defamation. Several months passed by, and then on the 30th of July, a claim form and statement of claim was filed against Ms. Joseph on behalf of the Prime Minister, setting out an allegation that she made a statement that she knew was false, and she deliberately made the statement to injure his character. Within the context of the statement of claim, there was an allegation, an assertion that the Prime Minister had said that he was an investor in St. Mark's, and that erroneously Ms. Joseph had said that he was an investor in the shrimp farm project. When we received the statement of claim and claim form, again, it was filed on the 30th of July. We filed 1 week later, an acknowledgement of service.
Yeah.
It's a document you file in answer to a claim indicating to the court whether or not you're going to defend the claim.
Right.
And we emphatically stated on behalf of Ms. Joseph that she does not accept the claim and she intends to defend the claim. That was clear.
Right.
She said she didn't accept any part of the claim. So it was clear that Ms. Joseph intended to defend it. However, in order to file the defense, we wanted to be sure of a few things. One, because we don't have a memory like a tape recorder. Ms. Joseph didn't have a recording of the speech of Dr. Mitchell, because he used the speech as a foundation to the claim, to say, I made a speech saying certain things. We needed to have the entire speech to get the context. Of what he said.
Right.
And also, we thought we needed to have, because Ms. Joseph couldn't lay a finger on or lay her hands on, so to speak, the recording of the statement she made herself. And given her defense, we thought it was essential to be able to interpret both statements in context, because defamation, libel, slander, they are to be interpreted contextually, because I may make a statement which follows up from another statement, and in the context, right, it may be justified, even though it might cause damage to a person's character. But based on the surrounding statements, the proper interpretation of the statement made might afford a defense of justification. We asked for three things.
Uh-huh.
So on the 6th, and notice the timeline, his claim was filed on the 30th of July. We acknowledged receiving the claim. 7 days later, on the 6th of August, very quickly, we responded.
Right.
And on the 12th of August, that's another week, less than a week. So within 14 days, within 14 days, we sent a document which is called a request for information. It's an official document. We filed it in the court registry, and we served it on Dr. Mitchell's lawyer, asking for 3 items of information. One, in the claim, it is claimed that he was minister responsible for CBI. In our recollection, we believe that he was not the direct member for CBI, but Minister Joseph or another person in the cabinet had direct responsibility, right? And he was just a general minister. So we wanted to confirm that. The second thing we wanted from him, that's Dr. Mitchell, was the transcript of the little speech that he gave in the sword turning ceremony, given that he's claiming in the claim that he said he was an investor in St. Mark's. Yes? We asked for that. Right, that was the third part. We received no acknowledgement from Dr. Mitchell or his lawyer until the 15th of October. So more than 2 months later. More than 2 months later. We got an extract from the speech. Let's say we got what they say was the transcript of the speech. And we got snippets of Miss Joseph's so-called statement. Not even complete sentences. We got snippets of what they claim Miss Joseph said. It was not a full transcript, and the statement was that they did not have the audio recording. What we are saying is that if they are saying that she said certain words,
then present it.
Just present, evidence of it. That's what we are asking for. Yes, because Miss Joseph was unable to recollect our exact words. Right? And as a matter of fact, in that response, it just underscores that they were pulling a few words out of an entire context and using it. Yes? Now, in that context, we got in on the 15th of October. We studied the response and realized there was a bit more information that we'd have liked to have. But in the spirit of practice, what normally happens, once a request for information is filed and it is complied with, remember, they did not acknowledge receiving the letter with the request for information. So 2 months went by, and they did nothing. And then they sent information. The information was not signed by the claimant, which it should be. It was signed by Mr. Stewart or somebody on behalf. And that's another issue which I will take up later.
Definitely.
He didn't sign the request for information, which he should have. Or his lawyer should have given a good reason why he did not sign. No proper reason was given for him not signing the request for information. Dr. Mitchell did not sign the request for information. However, in view of the fact that it's a defamation case, it depends on interpretation of what is said or what is written.
Absolutely.
So we realized time was running out to file a defense. So we wrote, and that's what lawyers do. Because the purpose of litigation is to avoid what you call ambush. The courts encourage the litigants to put all the things out in the open.
Put it on the table.
When it's on the table, then people can decide, okay, let's compromise because now I see what you're saying. I understand. That's what the courts encourage. Anyway, no response, as I said, until they sent that request, that response on the 15th of October. So we wrote just a formal letter, lawyer to lawyer, saying, look, can you agree on an extension of time to file the defense? because there is some more information we think would be relevant. And we suggested in that letter on the 30th of October that maybe we get an extension of approximately 28 days to the 9th of December.
Right.
That's what we ask.
Okay.
Right? To the 9th of December for us to file a defense.
Okay.
And in the meantime, we ask for further information because what Dr. Mitchell's lawyer was claiming was that he had other investment in St. Mark's. So we also asked for further information.
Yeah.
Give us the information as to what
Other investment.
investment you had in St. Mark's.
Naturally.
That was the second, because based on my instructions,
Right.
Dr. Mitchell's only so-called investment is the house that he built.
Okay.
No, that's not an investment.
So would you conclude, therefore, that the reporter, Ms. Straker, may have been misinformed?
Well, she was definitely misinformed. I'm not saying she lied. She was misinformed.
No, she may have been misinformed.
Right. But there is something even more interesting. And apparently, Mr. Stewart, counsel on the other side, and his darling wife, who is the Minister of Legal Affairs, seems also not to understand the basic fundamental rules of practice. The failure to file a defense in a matter does not carry with it any automatic sanction from the court.
So it does not constitute any sort of benefit to the claimant.
No, that's not it.
matter.
There is no sanction. There is no punishment.
There's no punishment for not filing
for
on
not
time.
filing on time.
But this precisely was what was conveyed by the
It is wrong.
reporter.
It is
So
wrong.
It is wrong.
It is wrong.
Okay.
The Privy Council has emphatically
Yeah.
underscored and emphasized that when there is no sanction in the rules for not doing something properly,
Yes.
one has to go to the court in a formal application and show the court that they
Why?
deserve to have a judgment.
Okay.
Now listen to this. In this matter, Dr. Mitchell could not have gone to the registrar and gotten a judgment in default because the claim contained a request for an injunction and the registrar can't give it. That's the first point. The second point is that you can only get judgment in default when you apply formally to the court for judgment in default. And no formal application was made to the court. What happened is that in the affidavit that was filed on the 25th of January 2021, Dr. Mitchell, on Dr. Mitchell's behalf, they're asking the court to give them judgment in the affidavit. And interestingly enough, and they didn't tell the public that was refused by the court. The court did not give us an extension of time, and the court did not give judgment specifically. Therefore, and let me say this again. In October, after we got the first information from Dr. Mitchell, on Dr. Mitchell's behalf, rather, we had a defense prepared. In drafting the defense, we wanted to be very open-handed and clean and clear with the court and be specific in the defense.
Right.
So we thought it would have been useful within the context of what investment Dr. Mitchell had in St. Mark's to be given the information.
Yeah.
So at that point, we could have, in our defense, say, okay, fine, yes, he has an investment, a mistake was made, or whatever the case might be. And that was a genuine reason. When I had the discussion with my client, Ms. Joseph, I repeat, 7 days after receiving the claim, said to the court, I am willing and I am going to defend this case. It was clear and open. So there was no sneakiness. There was no misrepresentation, not trying to hide, not trying to delay. There was a genuine attempt to get information. There was no communication from the lawyers on behalf of Dr. Mitchell.
Right.
And the request in an affidavit was rejected by the court. The request for judgment. The court decided, no, we're not going to give you an extension of time. You should have filed your defense before and then amend the defense while you're waiting. Which again, in my humble view, it's a waste of the court's time. Why go through that and amend defense and wait for information? When, if in the true spirit of litigation, because remember, this is a matter in the public domain.
Right.
It concerns state property. It concerns a project that was touted by the present government to be liberating for the poor people in St. Mark's.
Yep.
It was touted as a groundbreaking project that will bring millions of dollars to the coffers of Grenada.
Yep.
It is a project which has benefited from scores, maybe hundreds, because I don't know yet, Terry, maybe hundreds of our passport.
Yep. Associated with that particular matter.
I repeat, Terry,
Yeah.
the money funding that project belongs to Grenadians. It does not belong to the investor, the fly-by-night investor. Let me make this point again. I have said time and again, Terry, if a project raises money based on Grenadian passport, which belongs not to Dr. Mitchell, but belongs to all of us, it means that Grenadians must have a share in that project.
Yep.
It is madness to tell me that you sell 100 of our passports and an investor has all the money in their pocket and we get nothing and they walk away with the money.
Well, they walked away with it, almost $54 million.
So I am saying, Terry, in this situation, it's a matter of public concern and public interest. And
absolutely.
And it concerns freedom of expression, freedom to criticize our leaders. If you don't want to be criticized, don't go for public office.
Stay away.
We have a man as Prime Minister. He's been in public office for 30-something years, and you can't criticize him. You can't say anything.
That's ridiculous.
We have a man who has been associated with this cause of crooks and conmen. We have a man, Terry, who, when the briefcase scandal came out, he swore that he was going to sue everybody. He has sued nobody.
Absolutely.
We have a man who has encouraged crooks and conmen to be representing Grenada, Victor Cosini, who's in jail now. We put him forward to be ambassador in London, and the Queen had rejected him, and we still did not remove the diplomatic passport for Victor Cosini. He's in jail all now. The gentleman with the briefcase scandal, he was rejected when he was put forward as a diplomatic agent on behalf of the government of Grenada. And our government, our Prime Minister, continues to defy the Vienna Convention in his appointment of ambassadors. So these are issues in the public interest. So we thought, based on the nature of the claim, the Prime Minister is the one who's suing a citizen of the country. He should come with open hands. If he says, I'm an investor in St. Mark's, tell us where the investments are.
Put it out on the table.
But they can't say that. But they're rushing and making all kinds of statements.
Well, I consider it mischief.
Well,
because Ms. Straker, as the reporter on the matter, tried vigorously to give the impression that Prime Minister Mitchell has won a battle.
Well, let me answer it from that standpoint. If Dr. Mitchell wants to win a battle so badly, I have bad news for him. He hasn't won anything.
Not at all.
But the other point, which I need to make, Terry, as I said, I did not appear in the matter. My son appeared in the matter. It was not a weighty matter. The matter before the court was not a weighty matter. It was a standard application.
A standard application.
Yes. And I have had no report from my office. I repeat, I have had no report from my office that anyone called my office to get information regarding this matter.
Wow.
Nobody, I can say emphatically and definitively, that no one called my cellular phone to get information on the matter.
Rather interesting.
So maybe there are persons who want to make a political game of this claim. That is not going to happen. This is a matter for the courts to decide. The courts will decide it.
Yeah.
And whatever shorthand practices other persons want to follow will not be successful. So Dr. Mitchell will have to come really good. I understand somebody said, my brother came to me last night and said, oh, somebody wrote up on Facebook, oh, the almighty Cajeton Hood lose. I didn't know he could have lose. I'm not almighty. And I have not lost.
But that is the perception out there that you have lost the case.
Well.
Because of false reporting.
Let it continue. As I said, there is no sanction in the rules. Just to summarize, there is no sanction in the rules for not filing a defense in 21 days. But don't get your victory in the press.
But could a registrar issue a default judgment?
In this case, no. And I think Mr. Stewart knows that. That's why he did not make the application before the registrar. And then I believe also, in normal practice, Terry, once the issue of request for information is out there, lawyers don't ask for default judgment.
Yeah.
It's normal practice. It happens to be scores of time.
Courtesy.
The other person, yes, the other person is asking for information.
Yeah, then obliged.
The first insult and injury to the practice was when we received no response from the lawyer at all, not even an acknowledgement of the letters, nothing at all. And you don't practice the law that way. Somebody, the other side asks for information, you call the other side, or you say something, or you send a letter and say, look, we don't think information is necessary. As a matter of fact, Terry, they responded to the first request for information, albeit 2 months later.
Okay.
You see? So as far as they assessed it, that information requested was reasonable. But the information they gave, we thought, was insufficient, because they were claiming in the information they granted, based on the Prime Minister's statement in his speech, that they were claiming. He didn't say in his speech, and that's the other point. He never said in his speech, and that was disclosed in the information. He didn't say in his speech that he had investment in St. Mark's. He never said so in his speech. Hear what he said. He said, my sister, that sister Clarice Moser, knows, I am investing in St. Mark's. In other words, he told his sister to get some workers for him. Okay, he can't go big. He's investing. That means he has an intention to invest. And that's the reason why we said, tell us which investment you have in St. Mark's now. Yeah. To speak good Canadian parlance.
Reasonable.
Tell us which investment you have. Because your lawyer saying in the claim that you are an investor in St. Mark's. Okay, Papa? Tell us, Papa, which investment you have in St. Mark's. And they couldn't answer. In the tape, he's saying, well, I want to have, or I am having, or I am investing. That is present continuous, not past.
Serve me correct. I think the statement was, I am also an investor.
Yes, that's what he said. But he said, I'm an investor, and then he said definitively, I am investing. And to the people who study English language, and I hope our Prime Minister studied English language, the tense means not that anything has been done. It's a present continuous. It's futuristic. It's futuristic. Right? So if I have to give him an English language lesson, here it is, Dr. Mitchell. The tense regarding your investing is not something done in the past. And that's why we ask you to tell us what investments you have or you had at the point of the speech. That's what we are trying to establish. At the time when he gave the speech in the sword turning ceremony in the shrimp farm, did he actually have any investment in St. Mark's? That's what we are asking him. And up to this date, he can't say why. Because the second request for information, put them in a corner and say, please tell us the investment, tell us the date and the type of those investments that you are claiming you have in your statement of claim. That remains unanswered.
Well, time will tell.
Time will tell. So if those out there are hoping for me to lose, Sorry. It hasn't happened as yet. They promised us in 2019 an investigation.
Mm-hmm. Yep. Of the $54 million.
Well, I don't know the figure.
Yeah, not $54.4 million.
Is that US? Is that US or EC?
EC disappeared.
Yes, that's about.
You're talking close to about 20 million US, approximately.
No, I am looking at our assets.
Oh.
In that, hold on. In that, that's about 200 of our passports.
Approximately.
If it's $250,000 for one passport.
Mm-hmm. Approximately that amount. Yeah.
About 200 of our passports. Yeah. So the Grenadian citizens must know.
Yeah.
That maybe if we go at $250,000 per passport,
approximately, yeah.
Right. If that's the current state of the law, because the Prime Minister has been changing the figure regularly. Since the Act was passed in 2013, he has been changing it up and down to suit whatever purposes he has. So if it's $250,000 per investor, then you are talking approximately over 200 passports.
That's right.
And Grenadians must know these are the number of our passports that have disappeared into unknown hands, because the Prime Minister went to Parliament and got Parliament to agree that they were not going to disclose the names of the person who got the passport. Yeah. So Grenadians, there are over 200 unknown persons walking out there with our passports associated with that nefarious shrimp farm that your Prime Minister is suing an ordinary citizen on.